President, I move the bill pass, and speaking to that motion.
Senators, the floor.
Thank you, Mr. President. Ladies and gentlemen, this bill has a little bit of complexity to it, and I hope you'll indulge me while I just explain to you what it does. It's a bill that basically completely revamps our expungement and record sealing system for people who are either acquitted or convicted of crimes. First of all, it expands our existing expungement system to allow people to expunge underage alcohol convictions or deferrals. Same thing for underage marijuana possessions or deferrals, or underage tobacco convictions or deferrals. It builds on our existing system for that. Second, it creates a small automatic sealing program. Senator Lucas has been a leader on this issue, carried a bill during the special session and also this year, which has rolled into this, which was recommended by the Crime Commission. This is a smaller version of that, but it basically allows the automatic sealing of class 3 or 4 misdemeanors where nobody was arrested. Class 3 and 4 misdemeanors don't carry jail time, but every once in a while somebody gets arrested. Traffic offenses and all, it allows for automatic sealing of those. The big thing it does is that for convictions, either class 1 or 2 misdemeanors, undefined misdemeanors, or class 5 or 6 felonies, it allows somebody, after a period of time and showing good behavior and showing they've been rehabilitated and showing and also just not having certain types of convictions, to petition to a judge with a notice to the Commonwealth Attorney and after an evidentiary hearing to have a conviction sealed, up to 2 in their lifetime. DUIs and domestic violence convictions are excluded from this pursuant to an amendment you all made yesterday. There are restrictions on the time frames within which you can petition for this based on the nature of the crime. For example, moral turpitude crimes or the level of the crime, you have to wait longer for the more serious the crime is. And in order to get a record sealed, you have to show there's a manifest injustice, and you have to show you're no longer addicted to drugs or alcohol. What it does is it injects discretion into this type of system. So it's not automatic, it's discretionary, which is very important. That's the way it's done in most of the states that do this. In terms of one of the things that we heard during the process was that people were concerned that a petition process would limit access to record sealing. So we created a court-appointed attorney fund, which is funded by the expungement costs that are paid on sealing, the fees that are paid on sealing petitions. So every time somebody files a petition to seal, that money is put in a fund which pays for court-appointed people who would otherwise qualified for court-appointed counsel. The second thing we did is we created a process by which when a charge is dismissed, the lawyer, while standing there, can ask for an expungement. If the Commonwealth Attorney does not object, the charge can be expunged right there on the spot for dismissals. And that's important for some reasons I can get into if anybody wants to talk about it. Another way this differs from other bills is that this allows people who are hiring people for certain jobs to access sealed records with the consent of the person applying for the job, and they can ask for it depending on the nature of the job. There's a list of different employers which are included on that list, and also the state police is given discretion to promulgate regulations to greenlight certain employers to ask about criminal convictions that have been sealed. For example, anybody who's applying for a job that requires a federal security background clearance, the federal government can see everything, whether we seal it or not. And so it's important that employers know that they're not hiring somebody that's going to fail a background check. The next thing it does is we took the language from Senator Lucas's bill about data brokers, and we incorporated it into this bill. We made some slight modifications to it. Both my original bill, Senator Lucas's bill, and this bill contain a private right of action against data brokers. That's been in all 3 bills from the very beginning. The amendments we made in the Finance Committee simply added a cure process, which is a more business-friendly approach to the matter. The reason it's important to have data broker liability is because we can seal or expunge things all day long. But if private corporations continue to publish information about charges that have been expunged or sealed, the expungement or the sealing is completely worthless. It'll continue to show up in an employment background check or a landlord-tenant screening or an insurance screening. Or there's these other services that just sell information if you want to check out your neighbor, who are completely unregulated right now. The last thing, Mr. Chairman, Mr. President, is the bill has a 3-year delayed enactment clause, which is necessary to implement the computer infrastructure to get this done. It also creates a working group to talk about ways to better refine the record-keeping process to see if there's ways we can sort of destroy records instead of keeping them sealed. There's some offenses where we probably don't even need to keep the records, but basically right now all we do is seal them, and under this all we'll do is seal them and sort of park them in a file cabinet. But it's a pretty complicated bill, Mr. President. I'm happy to answer any questions anybody has, but that's sort of a summary of what it does. Hope we can pass it.
Thank the senator. For purpose, Senator from Rockingham, Senator Obenshain, rise.
Mr. President, rise. Ask the senator from Eastern Fairfax if he will rise to answer a couple of questions.
Will Senator yield?
I'll yield for a couple questions.
Senator yields for a couple of questions. You have the floor.
Mr. President, I would ask the gentleman, yesterday, as I was listening to the explanation of the substitute that was laid on the table and submitted, my recollection was that it was described as essentially addressing the sealability of records related to DUIs. But in going through the bill, I see sections E and F on lines 658 through 676. Are those new provisions that were not taken up in Finance or any other committee?
Senator has the floor.
No.
Further questions?
Mr. Chairman, I'm happy to elucidate further, but the only thing in the amendment yesterday, and I can cite you to the exact lines if you want to know them, was that we excluded DUIs and domestic violence convictions from the ambit of the bill. That's the only thing the sub that yesterday did, and I'll give you the line numbers if you want to see them. The bill that came out of the Judiciary Committee had a private right of action in it, and the only thing that was added in Finance relating to that section was we created an opportunity for the company that sued to make a cure offer so that they could say, hey, I'll fix this problem and you can't sue me. And that was what was added there. I would note that the only other thing that was added in the Finance Committee as part of those amendments was the right of the consumer to request a copy of their own report. That was requested. And there was also a provision added that requires the state police to confirm the identity of the data screening company before releasing a list of expunged charges to them, which is critical because there are these fraudsters in other countries that want to get their hands on this data to put it on the internet and extort people. And so it just requires the state police to confirm they're dealing with legitimate companies when these lists are given out of very sensitive information. That was the only things that were added in the Finance substitute.
All right, Mr. President, speaking of the bill,
Senator has the floor.
You know, in going through this, this is a complicated bill, and these data companies are data companies that many businesses rely on for information that they get in background checks on people who are applying for jobs. And I know that we are providing for the expungement of certain offenses, but what this bill also requires is that these data companies go back and after they have already collected this information about criminal offenses, it requires them to purge that from their records, which is fine, and it's a policy decision that we may have made, but we're asking a lot of these companies. And the bill, as it existed, it allowed for the Attorney General's office to essentially pursue complaints and pursue remedies against these data companies if they fail to purge their records and take out expunged offenses. And it provides for up to $2,500 civil fine against these companies. And it put that squarely in the Attorney General's lap. What sections E and F on lines 658 to 676 do is something dramatically different. It creates an individual cause of action. So if I've been convicted of or if I've been had an offense expunged from my records, yet ABC Corp, which collects this data and provides it with consent, my consent, to potential employers, hasn't deleted it by accident or intentionally or otherwise, this gives me the ability to make a complaint, to allege that that's a violation of this statute, to sue ABC Corp for violating this statute. The remedies are not capped at $2,500 as the Attorney General's remedy is capped, but it is the greater of $1,000 or actual damages. So, heck, if I don't get the job, I'm going to claim it's because of that information that was in the report. And I'm going to claim that I've lost $100,000, $200,000, $300,000 from my inability to get that job. So it's the greater of $1,000 or actual damages, but that's not all. It is also attorney's fees and costs on top of that. But as Senator from Eastern Fairfax points out, it does have the letter of cure, which sounds good, but it's not so good. It's what federal rules of civil procedure call an offer of judgment, basically, pursuant to which ABC Corp can say, all right, Obenshain, I know, we screwed up. We forgot to purge that out of the records. We're going to make an offer of judgment to you of $1,000 or an offer of cure. And I can accept it or I cannot accept it. And they would be excused from paying those attorney's fees, but only if the judgment that comes in is less than $1,000. If it's more than $1,000, they get tagged for everything. So, this goes well beyond expungement. This goes well beyond what I think that the committees took up, or at least what the Crime Commission took up. But then again, I wasn't in the Crime Commission. I don't think anybody on this side was on the Crime Commission, had an opportunity to participate in that. But I just caution the members that this is opening Pandora's box. It's creating a big new remedy for a big new statute, which already had enforcement provisions, and it's creating this brand new large lawsuit without even figuring out first whether the executive or administrative enforcement provisions are even going to work. So I would suggest that the members vote no.
Thank the senator. For what purpose, Senator from Hanover, Senator McDougall rise?
Thank you, Mr. President. Mr. President, speaking briefly to the passage.
Senator's the floor.
Thank you, Mr. President. Mr. President, yesterday I asked the senator from Eastern Fairfax if this legislation enabled you to have your record sealed for embezzlement. And I think I asked him about a specific term, and he indicated yes. Mr. President, I think that some of the items in this bill are really important, and we could all coalesce around. There are a number of misdemeanors that we could coalesce around being expunged and or having your record sealed. But Mr. President, when we move forward to things, employers have a right to know if somebody has been convicted of grand larceny, which means they stole over a certain amount of money, or embezzlement from another employer. And Mr. President, as we move forward in this continued discussion, I will be voting no on this legislation, but I hope as we go forward, there will be a recognition that there are some offenses that the public has a right to know if you've been convicted of them. And particularly, employers have the right to know before you would be employed if you embezzled money from a previous employer.
Do any senators other than the patron wish to be heard regarding Senate Bill 1339? Seeing none, Senator from Eastern Fairfax, Senator Surovell.
Thank you, Mr. Chairman. So let me just try and assuage your all's concerns about a couple things. First of all, as I said earlier, employers, if they're hiring for certain jobs, are allowed to ask about charges that have been sealed, like embezzlement. They're allowed to ask if they're in a certain category. And if there are other employers that don't feel like there's a category in the code that, as written that applies right now, they can ask the Virginia State Police to include them in the regulations that are going to be promulgated. But we dealt with that, and that's how it's dealt with in most states. If you're concerned about the absolute expungement of larceny offenses, I would suggest that you vote against the version that the Crime Commission recommended that might be coming over, because that one automatically expunges petty larceny and grand larceny convictions. Automatically. This one requires you to go in front of a judge and show that you've changed your ways, that you're not still breaking the law. And so if you have one that's 10, 15, 20 years old, I would think you'd be able to show that if you lived a good life after that. That's what this one does. It injects discretion in the system. The second thing, in terms of the Attorney General authority, the AG's authority and the private right of action have been in every single bill that was introduced this session. It's not, the private right of action is not anything new. And so I would also note that it's not clear to me that folks understand what the current state of the law is. Since 1993, when the Fair Credit Reporting Act was adopted, and then when it was amended in 2005, whenever you do a background check for employment, or whenever you do it for housing, whenever you do it for insurance, there's liability under the Fair Credit Reporting Act for publishing inaccurate background checks. That's been the law in the United States of America now for 2 decades. And so if a background check company publishes an expunged charge, right now, today, you can sue them. If a landlord gets an inaccurate report, you can sue the background check company. That's the law today. What this bill does is it gets to the companies that are selling the data to the screener companies, because you cannot sue the companies that aggregate the data and keep these massive databases about all 39 of us and then sell it around. They are the source of the problem, and they have escaped liability under federal law so far. This goes after that. It also goes after a second thing, which is there is a class of unregulated data providers. For example, if anybody would like to see, I've been collecting these. I have a whole series of emails, solicitations from this company called My Life. And about every other day, they send me an email that says, Scott, negative items on your reputation profile can affect what people think of you. Look up your profile now. And every day, they send me... Yeah, and every day, about every week, they send me emails telling me, hey, I can also look up my dad and my brother because there's bad stuff about them. They also say, hey, look, here's your neighbors, and you can look up stuff about them. And because you're not pulling that data for an employment report, because you're a landlord-tenant situation, or because you're pulling it for an insurance policy to get some economic benefit, it is totally unregulated data. So these companies are currently allowed to put out all kinds of inaccurate information about you with zero liability. This bill is also designed to affect the proliferation of inaccurate information about every person in this room and every Virginian. So that is what it's aimed at. The employer situation was just described is already covered. The landlord situation is already covered. This gets at the people who are causing the problem. So, Mr. Chairman, this is going to be probably the first of, who knows, probably 4 or 5 times you're going to vote on this bill before it gets to the end between conference reports and everything else. I would just ask you to keep an open mind about it and keep this process going, and we're going to get a better product when we get to the end. I hope we can pass it today. Thank you.
Thank the Senator. Question and shout. Senate Bill 1339 pass. All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 21, noes 17.
Ayes 21, noes 17. Senate Bill 1339 passes.
Senate Bill 1341.
Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. Senate Bill 1339 passes.